Hello, everyone, and welcome to Uncivil Law. For today's case, we are telling the saga of Barge B number 280 in the state of New York. Barge B number 280 caused a bit of a problem, an environmental oil spill that caused some damage, and we are going to read the case to try to figure out what the liability issues as it relates to Barge B number 280. The tale of the barge must be told. Let's get started with this. This appeal arises from the discharge of several thousand gallons of oil into Long Island Sound from a submarine cable. That is an underwater system that transmits electricity and through which a dielectric fluid is pumped as a lubricant and coolant. So there is a electrical line underwater, and it also has fluid in the line to lubricate the line and cool the line, which apparently is important. The Power Authority of the State of New York alleges that the dropped anchor of Barge B, number 280, which was being towed by the tugboat Bouchard, ruptured the cable which the authority owns and operates. So this poor little barge that was being towed by a towboat and had an anchor dropped, and the anchor ripped a power line, and the power line contained fluid, and now the fluid has spilled and created environmental damage. So, all sorts of fun stuff. The authority claims, pursuant to the Oil Pollution Act and the New York Spill Law, that there is a liability. The corporation defendant appellees, meanwhile, initiate a parallel proceeding pursuant a Limitation of Liability Act. So the government says you're responsible for oil pollution and oil spill, and the towboat or the barge people say we're not responsible or we're not liable because of the Limitation Act. Okay. The Southern District of New York determined the statutory definition of the term facility did not encompass the submarine cable because it was not used for any of the purposes enumerated in the definition. So the district court said there was no liability because to be liable, you have to damage a facility, and this is not a facility because it was not used for any of the purposes as designated in the act. As a result, according to the district court, the authority of New York did not have a viable claim under the relevant law to pursue costs related to the discharge. So the district court said you can't get liability because to have liability, you have to damage a facility, and this is not a facility because it was not used for any purpose that the act designates, okay? The authority owns and operates the Y49 cable system, a power transmission cable system that spans the Long Island Sound. There are 4 submarine cables spanning the Long Island Sound, with 2 self-contained fluid-filled pressurization plants located at the 2 ends of the cable. The 4 underwater cables are high-voltage transmission cables consisting of multiple layers, including an electrical conductor and a layer of fluid-impregnated paper insulation. Additionally, a central duct in each cable is filled with a dielectric fluid, which is hydrocarbon, petroleum-based oil, that acts as a coolant and lubricant to the electrical components of the cable. The 4 cables combined hold approximately 10,000 gallons of dielectric fluid at any time. So they are using an oil-based substance to cool and lubricate these electricity creating lines. And how much fluid are we talking about? Apparently quite a lot, because between the 4 cables, we're talking about 10,000 gallons of oil. So that's a lot of oil, but then again, I guess it's a lot of cable. So when we're talking about the damages, we're talking about, notable amounts of environmental damage from this result. On January the 6th of 2014, the barge, in the course of being towed, dropped anchor. Probably not a good idea. Shortly thereafter, the cable number 3 experienced an electrical fault. At the same time, the systems monitor reported a sudden drop of the cable, which indicated a leak. So they cut through cable number 3 by dropping anchor. Way to go. Probably shouldn't have done that. The government claims that it paid a very precisely accounted for $9,848,087.12 for the cost of fixing this. So just shy of $10 million, but because it's the government, we'll account for it to the penny. So this cost us $10 million to fix this. Okay, great. So now we have to figure out what the legal liability issues are that respond to this kind of damage. Congress enacted the OPA in 1990 in the aftermath of the Exxon Valdez disaster, with an aim to unify and supplement the then existing patchwork of federal regulations that governed oil pollution. Among its provisions, the OPA establishes a framework of liability and compensation for the costs of fixing oil spills. Under the framework, each responsible party for a vessel or facility from which oil is discharged into or upon navigatable waters or adjoining shorelines or the exclusive economic zone is liable for the removal costs and damages that result from such an incident. So everyone who's responsible has to pay for the damage. The responsible party is defined in reference to the source of the oil discharge in question. That is, a vessel, onshore facility, or offshore facility. So the initial liability goes to the facility, who is creating the facility. So presumably, if this is a facility, then the initial liability would be to the power company for their cost relating to the damages that caused. So this is like a strict liability thing. Strict liability statute. We don't care how it happened. You're the one who do it. You're the one who has to pay for it. Whether or not you can sue someone else is a whole nother set of problems. Okay. If the responsible party can establish that the discharge and liability were caused solely by an act or omission of one or more third parties, then those parties become the responsible parties for liability. So the initial liability is to the one who operates the facility, but if they can show that someone else is the sole cause, then they can shift liability onto them. Okay, great. And then it goes on to define what a facility is, which is obviously important as we're trying to determine if this is or is not a facility. So what is a facility? The OPA defines facility as follows. Any structure, group of structures, equipment, or device other than a vessel, which is used for one or more of the following purposes: exploring for, drilling for, producing, storing, handling, transferring, processing, or transporting oil. The term includes any motor vehicle, rolling stock, or pipeline used for one or more of these purposes. So if you're doing one of those things, then you are covered by this act. It also provides a separate definition for something that's offshore or onshore. Finally, the OPA contains a saving clause which governs the effect of the statutory scheme. The clause states, nothing in this act, or the Act of 1851, shall affect or be construed or interpreted as preempting the authority of any state or political subdivision thereof from imposing any additional liability or requirements with respect to the discharge of oil or other pollution by oil within the state or the removal activities in connection with discharge. So the federal law says it does not preempt. This is some liability that attaches, but states can also add to this liability if they want. The Limitation Act effectively caps the liability of vessel owners for claims for certain damages caused by vessels, limiting recovery to the value of the vessel in question and its freight. To enforce this cap, vessel owners may launch proceedings under the Limitation Act by which all prospective claimants must bring their claims. Once such proceedings are initiated, the Limitation Act provides any other proceedings to recover from the owner relate to the matter in question South Seas. So there is this Limitation Act which says that people can only be so liable, limit their liability, and if you want to invoke this, you can, and then all proceedings have to go through those proceedings rather than through other proceedings. So the defendant can kind of preempt or at least choose their ground if they want. So if they're sued one place, they can actually bring the complaint themselves as defendants and then bring it under their terms if they want. And that's one of the things that exists in this federal scheme of liability. The district court's decision was premised on the determination that the underwater cables was not a facility within the meaning of the law. In interpreting the provision, our analysis begins with the plain meaning of the law's text, and absent any ambiguity, will generally end there. So when we're trying to figure out what is a facility, good place to start, and sometimes a good place to end, is the text of the statute. Makes sense? Here we find the plain meaning of the OPA's definition of facility encompasses at least one purpose for which the transmission cables were used. To recall, the OPA defines a facility, as we discussed above, where it does any processing, storing, handling, transferring, possessing, or transporting of oil is a facility, excluding vessels. The crux of the question, then, is whether the utilization of this capability suffices for the cables to be considered used for that purpose. So the cables are primarily for electricity, one would imagine. And then the question is, does the fact that they're used for this other purpose mean that it is a purpose within the meaning of statute? And the court says, yes, it is. The definition's language requires nothing more than the cables be employed to transfer fluid. And it's clear from undisputed facts and records the cables are regularly used to, among other purposes, convey the fluid along the length of the cables and between the cables and the plants. So one of the questions here was, what is the purpose of these cables? And so one of the things the defense tried is say, well, the purpose of the cable is electricity. The fact that it has oil is kind of incidental. It doesn't really matter. It's not its purpose. These are electricity conducting conduits. So it's not its purpose to transport the oil. And the court says, well, that misreads the statute. It doesn't have to be its primary purpose or its predominant purpose. It just has to be a purpose. And as long as it's a purpose, it fits within the statute. So, yeah, it might be transmitting electricity too, but one of the things you're definitely doing is transporting oil. And so the statute applies to you regardless of what your primary reason for doing it is. It may be incidental, but it is within your design. You did design it that way to transport oil. So don't tell me it's not part of your purpose. You're using it for cooling or other things. That's like, okay, fine. It's still part of your purpose. So, yeah, the court says that doesn't make any sense, and I tend to agree. Because we hold these cables are used for at least one of the purposes specified in the definition of facility, the district court's conclusion the authority did not have a viable claim was an error. So yeah, it is a facility. Go argue about the other legal issues, but you made a mistake in dismissing it on that ground. The district court's decision to transfer the authority's claims to a limitation proceeding, predicated as it was on the finding that they did not have a claim, was an error as well. So you shouldn't have transferred this because they do have authority under the OPA, and that the OPA is something you have to go analyze first. So you made a mistake in transferring that claim. Thus, that brings us to the end of the discussion of power authority of the state of New York versus barge B number 280. In this case, we learned that a barge dropped anchor and it severed an electrical line, and the electrical line contained oil in it as a cooling mechanism, and so there was an oil spill that caused about $10 million worth of damage. And the district court dismissed, at least in part, because they said, well, the power line isn't a facility within the meaning of statute. And the Court of Appeals says, and I think quite rightly, that the statute only speaks to a purpose, not predominant purpose. So the predominant purpose might be electricity, but you did design it with oil in mind. It does have a purpose of conveying oil. The reason you're doing it is for cooling and all, but it is part of the design purpose. And so you can't get out on this claim. So the district court made a mistake by dismissing this case and sending it off to the limitation board. So take another crack at it, figure out the rest of the legal issues, but at least for the moment, that's the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.